Good morning. Happy Black History Month. The first day of Black History Month is February 1st, 2019, and I'd like to welcome you all to the Afrolantican Legal Academy. This is our first episode. My name is Andre Smith. Others call me Smitty Bonton, Professor Bonton, Professor Smith. It really doesn't matter what you call me, for the most part, that is. Anyway, so I am a former law professor for 15 years at American Association Law Schools. I taught at Penn State University, Dickinson School of Law. I taught for 7 years at Florida International University College of Law, also Widener University or the Delaware Law School down in Wilmington, Delaware, and also at Howard University, my alma mater, as far as the law is concerned. And so after teaching at those schools, I decided that it was time to teach law from a different perspective, and more specifically an Afrocentric perspective. If you attend a AALS member institution, of course you want to be a lawyer, pass the bar, and maybe work pro bono, maybe work for a public defender, or make a whole lot of money in a law firm, which is nothing wrong with that. However, to do that, you teach law from a particular way, from an American style, what we call a Langdellian style, of case method style, where you learn how to research American law and apply it to particular cases. We're going to do something different here. This is a more broader concept, a little more liberal artsy, if you want to call it that. What we're going to do is we're going to go through, at least at first, we're going to go through, let's say, 6,000 years of African legal history, and describe the states of pre-colonial Africa, and also describe, amazingly, a extraordinary commitment to equal protection of the law. We're going to go through that legal history because it was going to, so we can introduce you to legal systems, the basics of the executive power, judicial power, legislative power, because yes, we did have legislatures and whatnot and councils of state in pre-colonial Africa, and then we're going to take that all the way from ancient Kemet, Tasseti, Egypt, Nubia, all the way through the great states of Ghana, Mali, Songhai, states in between, Kanem, all the way down to Monomotapa, and the very several that existed prior to colonializations in this current form of slavery. And then take that into American critical race theory with scholars such as Kimberly Crenshaw, Derek Bell, to show that that commitment to anti-subordination of groups of equal protection has been durable for the last 5,000–6,000 years. And that will lead us in, after several episodes, that will lead us into the actual teaching of law classes. So from a kind of historical liberal arts approach to African and African American legal history, what I will call Afrolantican jurisprudence, then we're going to go into very specifically teaching particular law school classes, the full curriculum, constitutional law, property, contracts, torts, criminal law, trademarks and copyright, taxation. I am myself trained up as a tax lawyer, as a matter of fact, so what you're going to get is a lot of economic terminology and an economic approach to things, along with, of course, justice. That's inescapable, but I embrace law and economics. But we're going to be teaching an entire law school curriculum from an Afrocentric perspective. There's different questions that you would ask if you're trying to study law from an Afrocentric perspective. There's different themes that you would concentrate on versus if you were just trying to learn how to win or lose a lawsuit. So what we're ultimately trying to do, or at least what I'm ultimately trying to do, is trying to study law as it has been, so that we can eventually come up with the better system. right? I mean, what's the point if we're saying that this system is racist or sexist, whether it's capitalism, socialism, communism, whatever you want to call it? It's one thing to pick out all the flaws, and we do that all the time, but the better question, or the deeper question, and the one that I don't think is asked much in AALS law schools, especially amongst my colleagues as we call critical race theorists, or even black nationalist theorists, or Afrocentric theorists, is what is the better system? What is the system that we can learn after learning from what has been and learning what is? How do we examine those flaws and then correct them? Right, to come up with a system that is better, that would be more meritocratic, that would create grander spaces of liberty and property, if that's what you want. Right? So as I give you my version of Afrolantican jurisprudence, understand that it's not the truth, or I don't present it as the truth. It is an invitation, as a matter of fact, for you all to get deep into the study of law from its core, from its foundation to its present, and then come up with what is the better system. It's not just for black folks, but the world needs the better system, as we see what's going on around now. Let me just also say that you're going to find where are these videos going to be found. Number one, please go to YouTube, my YouTube page, Afrolantica, or Afrolantica.com, and subscribe there. You'll also see me as Executive Director of the Economic Justice Law Review. So that is going to be again, not necessarily an Afrocentric perspective, but that's going to be a look at race and justice from an economic perspective. So there we often take law review articles from my colleagues and break them down into what I call asymmetrical market imperfections. Don't even worry about that right now. That's when we get a little deeper. I'm telling you, we're going to get into the core of what law is. When I say jurisprudence, I mean that. We're going to talk about all the theories from positivism to realism, textualism, formalism, every ism and schism that you might have wondered about or heard about. I don't want any conversation about the law to go on without you all understanding what it's all about. You don't have to agree. I don't agree with a lot of the stuff, but I want you to know what it is, and then be able to know what's good about it, what's bad about it, and then what is perhaps the better system as I see it, and then hopefully you come with how you see it. So we're going to have Afrolantica.com, Afrolantica, the YouTube page. There's also the Economic Justice Law Review, which again is not going to be original scholarship. We're going to be reviewing scholarship that's already out there and reframe it in an economic justice and race perspective. And then also, I got to promote myself and our products here, and so if you can go out and find Taxes, Death, and Trouble. We're also going to do a video series on Taxes, Death, and Trouble, but that's the book that I currently have out. It's called Taxes, Death, and Trouble: How Starve the Beast Tax Cut Policies Created the Black Lives Matter Movement. Let me say that again. How Starve the Beast Tax Policies Created the Black Lives Matter Movement. If we're not talking about taxes, we're not talking about anything. I'm going to put that on hold right now because we got so much. I'm telling you, we're trying to do, hopefully this video series will be daily. That's ambitious, and then we have years and years and years to go, because when we're talking about the law, I always say this: the law is not deep. It's vast and wide. There's other subjects that are much more complicated, that require your brain to fire faster in its synapses than the law. It's not the stuff of geniuses. However, it is vast and wide. So there's so much to talk about it. And the difficulty and the complexity of it is taking that vast and wide body of law and laws in different places and spaces, and then culling it all together and simplifying it. That's the trick. Again, for you law students, that's the trick. It's not deep, it's vast and wide. And how do you corral it into something manageable and teach it to someone else? Again, I can go down a whole another series on how to succeed in law school, and we will do that too. But we're going to move forward here. So again, this initial introduction to the Afro-Atlantican Legal Academy is going through my next book, After Taxes, Death, and Trouble. The book that I'm completing right now is called Afrolantican Jurisprudence, right? Equal protection in an Afrocentric look at the legal history of Africa and its extraordinary commitment to equal protection of law. That's a long title. We're gonna cut that down. But for right now, we're just going to go with equal Afrolantican jurisprudence. And so what I'm going to do now is we're going to run down the chapters of Afrolantican jurisprudence, just so you can also see right now where we're going and kind of give you a little more concrete idea of what I was just describing of how we're going to teach the law, not just from a historical perspective, but then from a doctrinal perspective after that, and how long a road is going to be. Because when we talk about all these different folks and different concepts, I hope you get a grasp of how interesting it will be to go through each one, and I hope I can hopefully hold your attention. Okay, so again, Afrolantican jurisprudence is about African commitment, the extraordinary African commitment to the equal protection of law. In order to talk about that, there's a few things that you got to understand that before you can really grasp that concept. I mean, it's simple to me at this point because I've studied it so long, but I always have to remember that it's sometimes extraordinary for other folks to even to know that there was African statehood prior to slavery, that before 1700 or 1600, for thousands of years, there were many states. And when we talk about state, we're not talking about a tribe. There were tribes. It's not a problem being a tribe. I don't think that some people think that's a negative connotation. It's fine with me because I understand that there was that and there was others. We're talking even greater than an ethnic group or a country. Right? When we're talking about a state, and again, we're going to use a pretty European or Eurocentric definition. We're talking about a state where there are several provinces and a central government, usually dominated by one ethnic group, and the provinces usually designated with several other ethnic groups, and the control over those territories being held through taxation and often military power. Right? The control of several provinces, a jurisdiction by a central government, usually of one ethnic group over several others. That's what we're calling a state. Right? Not just a tribe of one people or a gathering of several peoples or even a large country of people that all see themselves similarly. There's plenty of that. We'll talk about those too. But I'm talking about, again, like the United States, right? Or any African state at this point where there are 42, 35, 12 provinces that are governed over very different peoples with cultural distinctions and have you, and their own governments there, right? State, local governments that govern their everyday lives with a larger apparatus that calls together all of them together in military power and particularly through taxation to call themselves, again, Nubia, right? Or Kush, Kerma, or Egypt, or as we call maybe Kemet, Ethiopia, Punt, Yam, okay, and these are states that existed even before the Christian era. We can then go to Cuba, the Hausa states, Ghana, Mali, Songhai, Kanem, Borno, the Swahili states, several others, and Queen Nzinga's Angola. All of these states existed thousands, well, at least hundreds of years prior to colonialization, and sometimes thousands. And in some respects, they were more advanced than other states in the world, whether it be Asia, Africa, Asia, Europe, or the Americas. I don't tend to dwell on that, who's first, because I'm so proud of our history, and it is so deep that to get into every minutia of who did what first, it satisfies me to know that, yeah, we did a lot of stuff first, but anything we've done, we've been amongst the earliest. And I hope that this conversation about the ubiquity of African statehood and law and political organization convinces you of that to the point where it's what we call hegemonic, where it's just around you, like the air you breathe. You don't even notice it anymore. It's just ingrained in you. And I need it ingrained in you and our children, because ultimately what we're trying to address when it comes to our current subordination as a people is attacking the myth of black inferiority. It's often said, if you don't want to be nothing, doing nothing will get you there. And if you don't think you are anything, then it just becomes quite natural to say we ain't shit or whatever, and to do nothing with your life towards our advancement, to think that we always were here. It's kind of a, not a beef, but I don't really like to. I understand that this is 1619, the 400 years that African Americans have been in the United States of America, and I'm proud for everybody that celebrates it. It's not the biggest thing to me in the world, because I don't particularly care to start our history off at slavery in the Americas. For me, as an Afrocentric person, I take our history all the way back to its beginnings in Africa, whether the queen mother of all from millions of years ago, or from the states of antiquity, all the way through East, West, North, and South Africa to our dispersal, not just in the Americas. There were diasporas. There were diasporas of black folks that went to Asia and created great states on the southern coast of Asia all the way to Australia. So by looking at it from that perspective of us as a global people, I think that helps us debunk the myth of black inferiority that we see around us all the time, every day. Again, it's hegemonic, the assumption that we can't do anything positive, that everything has to have some negative attached to it. Now, again, please understand that when we present this African history, yes, I'm going to glorify it to the extent possible, but understand that it was not utopia. Right? The reason we're going to pick out certain states and certain places and talk about their greatness is to say that they were extraordinary, meaning they were not the ordinary, right? That they were better than or grander than those things around it, or even that particular country earlier or past. We're talking about moments and things to aspire to. So to raise our level of aspirations will raise our level of effort, and in order to do that, I have to convince, or we have to convince each other that we're not inferior, that nothing in this world existed kind of without us being involved in its creation, its production, and in some instances, perhaps it was better back then. I don't know. I didn't live back then. All I can say is when we deal with our current state of black subordination, our position in racial caste under a system of global white supremacy, all chips are on the table. All ideas are out there. There is not any one way that we're going to rise up. There's no silver bullet. What there is very myriad jumping off points and myriad activities towards combating our own subordination. And one of the ways we can do this is through, again, as Bob Marley might say, dismantling or emancipating ourselves from mental slavery. And through that, let me start with what we're going to discuss as far as Afrolantican jurisprudence and the extraordinary African commitment to equal protection of law. Ready? Here we go. So the first chapter that we're going to discuss, and we're going to only do this briefly. I'm so tempted to go on and on, as you see. I do that all the time. But I'm going to keep it short, and then we're going to explicate all these ideas and issues later in each particular episode. So we're going to have so many episodes dealing with all these issues. So if you miss anything right now, there'll be something tomorrow, the next day, the day after, the day after. Hopefully we're going to, again, do this daily. That's quite ambitious on my part. I'm going to try, and we'll see how far we get. So first, the first chapter in Afrolantican Jurisprudence is going to talk about the African origins of law. If any of you are familiar with the scholar Asa Hilliard, early on in my teaching career down in Florida International, I happened to meet Dr. Hilliard in a program sponsored by Carol Boyce Davies and Florida International University, the African New World Studies program. It was Dr. Hilliard, it was the great Theophile Mbenga, there was Dr. Martin Bernal, the author of Black Athena, fantastic stuff. And I had a chance to speak to Asa Hilliard, Dr. Hilliard, about whether Nubia and Egypt were the same state, or whether they were, I mean, this was early on in my introduction to kind of ancient African history, whether they were the same state, whether they were different states, whether the same people, different people. And he asked what I was doing. I told him I was a law professor very early in my career, maybe only my second year teaching. And he graciously emailed to me a text called a paper he had written while his son was a law student at Georgetown University Law Center, and it was called The African Origins of Law. Fantastic piece. I have it to this day. And he happened to pass on to the ancestors, to be with the ancestors, maybe less than a year after that. And so I'm very happy to actually have that and be able to hopefully republish that for you, so you guys can see how great of a scholar and how broad Dr. Hilliard was. With Dr. Hilliard and Theophile Mbenga and Dr. Diop and some of the other Afrocentric scholars like Chancellor Williams and those that even dealt with the legal subject, Joseph Ben-Jochannan, they were very much concerned about countering what's called positivism, or what I'm calling hyper-positivism. So one of the ways African history was excluded by Europeans is through this historical concept called positiveness or positivity. And it's not just being cheerful or optimistic. We're talking about letters, positive evidence, research. It's presented, and it is a rigorous standard for historians to judge other historians. How do I know what you're saying is true if there's no record of what you're saying, right? Now that's a rigorous standard, and it's definitely presented as a way to maintain quality, and you can't knock that very much. But however, it excludes a lot, and excludes especially those places where writing was just not conducive because of the environment or whatever the case may be. So we know these people existed, we know they had a history, and to the extent they have evidence of great populations of these people intermingling, how would it otherwise be organized but by law? But from a positive perspective, you can't say that, right? You have to prove it. So you have to prove that there is a legal code. And so Dr. Hilliard presents evidence that there were legal codes in Egypt prior to the existence of such codes in West Asia, such as Sumer and other places, particularly Greece. I take a different approach. My approach, I don't, from an Afrocentric person, I respect positivity. However, there is, even within those historical circles, the opportunity to infer, to imply different types of consequences or existence of certain things based on other circumstances that suggest its existence without there actually being a particular writing to prove it. And for example, let me just show you this example. I am very comfortable saying that women, African women, created law, right? Without a record that says African women created law, or these African women were the creators of law. Now, there are Greek writings that talk about Egyptians and Ethiopians and being the founders of law, but I'm talking about the concept of law itself. Who was the first to have a jurisdiction of land governed by rules after which, the breaking of which, society is expecting consequences to be dealt, right? That's what we're talking about when we're talking about law. right? We can give it other definitions, but just to distinguish it from rules and whatnot. Law, a jurisdiction, right? Society, expectations of consequences for the breach of those agreements that we all that have been created, either by a legislature, by an executive branch, by a theocracy, what have you. But to the extent they are regular and applied and expected to be applied by whatever is called society, we can call that law. And we can, without records, without a writing, we can surmise that that probably came from agriculture. And agriculture in Africa was always a female, was always headed by women, and is to this day for the most part. And why? How do we relate that to law? Well, if you're hunting and gathering, you take what you can get, you move on and whatnot. So we're talking about a lack of space. We're also talking about everyone having their own rules. When it comes to agriculture, society has to determine, there has to be a agreement on who can touch the corn. Whose corn is it? Whose land is it? What are the consequences for touching it when you weren't supposed to? So African women created law through agriculture. We're going to talk about that more specifically, right? So and then when we get to what is law and justice, or the first representation of it, it's a woman, Mot, M-A-A-T. The concept Mot, with the feathers, the arms outstretched, with the balance of justice. So in our first chapter of Afrolantican Jurisprudence, we're going to go through all that. We're going to talk about the origins of law in Africa prior even to Nubia and Egypt. But then, yes, the records that we do have become very intense when it comes to Egyptian law, or the law of Kemet, right? I mean, we're talking intense. After we deal with Mot and the gods Thoth and whatnot, we talk about certain peoples, right? The great Imhotep, who was the grand vizier of the pharaohs. Who was the vizier? A vizier is basically the prime minister, the attorney general. They wore different hats, and especially in the earliest of days, Imhotep was also the architect of the first pyramids. And we have a census. We have to track a listing of all the people of Egypt. And why? Because we're going to tax them. Everybody's going to contribute some grain or whatever they produce to the central government, that's going to redistribute it to the rest of the people, so that if I produce grain and you produce cattle and you produce craftware and bowls and chairs, I give a piece of mine to the state, which redistributes it to all the rest of the people. This is also how you're going to build pyramids and have a stash of food to feed everybody that's working there, through taxation, through the apparatus of the state. It becomes very regular, and the modernity of it, the extent to which it looks like today, is astounding. It is absolutely astounding. Not only do I teach tax, I teach administrative law. And we can even see from the first, I would call it, administrative law text, we're going to introduce the teachings of Ptahhotep, right? Who describes an administrative hearing and allowing the petitioner to say all that they can in order for a hearing to be just, even if you can't give the petitioner exactly what they are asking for. We're talking due process 5,000 years ago, and most specifically 2,000, at least 1,000, but I'm going to say about 2,000 years before there's any recorded invasion of Africa from outside, from the Libyans, from Hyksos, from the Assyrians, from the Sea Peoples, whoever was described as later coming into Africa to influence it. The Old Kingdom, Egypt, the first 6 dynasties, had law and governance, administration already on lock. And the teachings of Ptahhotep demonstrated. There's other writings later in Egyptian histories. We talk about the equal protection of law, specifically in the Tale of the Eloquent Peasant. The Tale of the Eloquent Peasant, a guy who a story about a poor guy who gets caught up by a rich landowner. Yes, ancient Egypt had private property. It wasn't communal entirely. Everybody didn't have the same thing. Even between the government and between the people, certain people had more than others. So so a peasant or a poor person runs up against a landowner that tricks him and steals his goods, even though he doesn't have anything much to begin with. And this peasant petitions the local governments and the court systems and pleads for them to treat him righteously and consistent with what? The principles of Ma'at, of order, liberty, of order and justice and balance and harmony, right, that governed Egypt for its entire 3,000 years. And that because he was poor, that he should not be treated differently. And this was a very important story within the canon of Egyptian jurisprudence. We also have stories about women suing their fathers, right? Women in ancient Egypt 5,000 years ago were their own legal person. They were not the property of their fathers. They were not the property of their husbands. Once again, the equality in ancient Egypt, the commitment to equal protection of law. We're going to talk about the venerated position of women in African society a lot, because the proof is abundant that that women in ancient African society, when it's at its best, are equal citizens, not only in occupations. We can talk about the female doctors of ancient Egypt. Imhotep is also deified as the father and god of medicine long before the Greeks. But however, the positive records show that the majority of, or it seemed a great deal of doctors in Egypt were women. And yes, the records about ancient Egypt of 4,000 or 5,000 years ago are that deep and detailed. We can even talk about, when it comes to equal protection of law, Queen Hatshepsut, the great Queen Hatshepsut. We're going to talk a lot about her. Probably the greatest queen in history, not just African history, just in history, period. Instead of arguing about Cleopatra, we need to do movies about Queen Hatshepsut and how she commanded an empire all the way from basically Kenya to Syria, right? An empire under her rule, and how she incorporated in her administration Asian peoples and whatnot within her government. And so it was truly a very strong attempt at early meritocracy between not just men and women, poor and rich, but also between foreign and domestic or different ethnic groups and what have you. We can even talk about Pianki and the great 25th dynasty, marching up from Nubia to reconquer Egypt and bring it all the way back to its old kingdom past that respected the rule of law and equal protection. And he is the first, according to Herodotus, to ban the death penalty. Right, the first monarch in history, recorded history. Right now, again, I'm not a hyper positive, so I will always leave open the possibility that somewhere else in China or somewhere else they banned the death penalty. But as far as positive records are concerned, we don't have any record of any monarch of a state in antiquity banning the death penalty prior to Pianki. And part of that was, again, to band the country together, because it had been split from upper to lower Egypt between Asian, Mediterranean peoples and the African interior. That's the story of our 3,000 year history in Egypt, the transformation of it from its African interior, 4,000 BC, where all the power is in the south, to its transferring slowly up to the north and the Mediterranean, where it basically resides today. So hopefully through Afrolantican jurisprudence, it can give you a stronger grasp on not just American law, but not just African law, but just the world we live in and how we've gotten from one place back in the day to where we are now, and why some of the fighting, a lot of it, the conflict in this world is a continuation of this grand story. All right, so we're also going to talk about matrilineality. one of the things we learned from Egypt and Nubia, and we talk about this transformation from the south to the north. What do we mean? We mean that culturally speaking, there were aspects of African state organization and law that were consistent. So we can call Sheikh Anta Diop, we call it an African cultural unity. He talks about totems, circumcision, names, language. They really, he and Theophile Benga, blew everything apart when it came to describing how African people, especially the Bantu-speaking African peoples, have a history that can be traced back to Nubia and the Nile Valley, just even stronger than one might tie ancient Eurocentric folks to ancient Egypt and Greece. Ancient Greece. That the line is that direct. To that, and that's I'd like to contribute to that with Afrolantican jurisprudence by also showing that there were a lot of legal techniques that were very similar in Africa, that when you see them different, when you see them change, it's usually due to some foreign influence, like the Greeks, Assyrians, Persians, or even the Arabs later. And one of those features is matrilineality, that African people's property, the crown, real estate, right? We just said that law is female, and therefore came from females' control of agriculture, the control of land. Who owns it? Well, what happens how does it pass from one generation to the next generation? In Africa, it had always been through the female, always through the queen mother. The queen mother has children, and her land is first of all going to be taken care of by the ablest of her sons, who also then take care of their sister's children. So the sister's children, yes, you could have a marriage and whatnot, but if that falls apart, there's always the uncles, right? And so men took care of, men were in charge basically of the queen mother's property, right? And so when a king dies or the head of the house dies, the person that takes over is not the son of the former king or the head of house. That's patrilineal. That's what we're accustomed to, the oldest son taking over for the father. Now, that's not the case in ancient Egypt and most of black Africa for thousands of years, that when the king dies, the queen mother certifies those of her sons or those of her daughters' sons that are eligible to take the throne, and those persons are selected or elected to then rule next, right? So often we'll see this when we see brothers taking the throne after their brother instead of sons after their fathers, right? And we'll also see queen mothers selecting their daughters as the regent, or even the Council of State choosing the daughter, a royal sister, or even the Queen Mother herself as a regent to take care of the land, to rule, while a child has been selected who's like 2 or 3 years old. They can't govern, and we're going to choose them purposely because we're going to allow this able woman to be the regent or outright queen. We're going to talk about the fact that ancient Egypt had at least 5 named pharaohs that were women. Right? From the very top, Narmer conquers both lands for the first dynasty. But as soon as he dies, Neith-Hotep is the queen mother, who then rules while the second pharaoh, Jer, is a child. Right? And then as he goes older and dies, his wife, Mernith, and we're not sure whether it was wife, because again, sometimes when we read Eurocentric scholarship, we have to convert it. Mernith, who could have been a royal sister, could have been the daughter of Neith-Hotep, takes over as the named pharaoh. So I believe it's the third pharaoh of the first dynasty was a woman. Then from Nitocris, the end of the sixth dynasty, Hatshepsut, in 18th. Then there's also royal Sebek Neferu. I'm forgetting some, and we're going to go all these in details. But the point is, ancient Kemet had several female pharaohs. They had queen mothers. They had royal sisters. Queen Hatshepsut also called herself the daughter of Amun-Ra, which has a religious connotation as far as something of a pope. Then we can, but that's not just ancient Egypt. African cultural unity stems from Egypt's connection to Nubia. Right? Nubia is actually the jumping off place. Ancient Kush and Kerma is where we have a cultural unity between southern Egypt, or what we call Upper Egypt, and Nubia, and from those, the culmination and the building up of that civilization then spreads throughout Africa. And we know we have the Kandakis, the Candaces, right? For all those who named Candace, right? You're named after queens, right? Those that ran ancient Nubia. And again, they reigned outright in name as Amanis, right? All those, if you're named Amani, right? Sometimes you could also say his name Faith, but you can take it also back 4,000 or 5,000 years and lay claim to the name of queens. And again, these queens were also elected. These kings were also elected. They were elected by a council of state. Again, Greek writers were astounded that the monarchy passed through a process, a regular process of elections. It's astounding. It's astounding, especially when we talk about the fact that we're told that we had no history. Then we find out that we have a great history, and then we find out that we had elections of rulers for thousands and thousands of years before we hear about democracy and other forms of government from other peoples. Even impeachment. Did you know that not only were African kings, especially those that followed the Nubian system, which was basically most, also impeached their king? They didn't have absolute power. Yeah, now they may have a great amount of power, but the Council of State could also order the king to kill himself. And this would happen ritualistically or symbolically, or it could happen actually. And that king or ruler is to take today's troubles and communicate them with the ancestors for their help. And this is a practice. And basically what we're saying is, it's an impeachment. Right? Things are not going good, and dude, you gotta go. And so we have this system of impeachment way back, and as a matter of fact, we see that once the Christian era starts around 300 400 AD, we have foreign influences taking over. So there's a King Ergomenes who, by 300 400 AD, is studied in Greek and learned in the Byzantine Empire, and so now he rejects the priests of Ammon. He rejects their call for him to abdicate the throne, and he has them killed. And so we have the switch from the abdication or the rejection of the ancient religious system, the ancient system of governance, or at least the transferal of power. We also have the transfer from a matrilineal system to patrilineal systems, which is taken even further by the influence of Islam. From ancient Nubia, which takes over, especially as the leader in African culture, as Egypt becomes more Assyrian, Persian, Greek, Libyan, etc., there becomes a lot of migrations, right? So as these people come to dominate northern Africa, those black folks or those Africans that were there previously and had power there, in order to escape the subjugation that they may face, go further south and west, right? And so we know that the history or the governance cycles that go through basically Lake Chad to West Africa down to the south, right? That's why they have a certain cultural unity with ancient Egypt and Nubia. But as we just mentioned, that was a great period. The next chapter in the book deals with Kharijitism and the influence of Islam. Uh, Islam is a very complicated subject when it comes to Africa and African history. On the one hand, Bilal, the Ethiopian, helps Muhammad conquer Arabia, and so there's a very friendly history. But very shortly thereafter, there is subjugation and domination, and we're going to introduce you to a brother named Al-Jahiz. He's an African Iraqi. So as I mentioned, different diasporas. One took East Africans from what we think is around Zanzibar, and we think that's why they're called the Zanj. It also could be derivative from the Zambia River, we're not sure, but most people assume from Kenya. They were transported to Iraq as workers in that side of the world, and they actually took over and created their own country in revolt. And the Islamic system that they instilled is called, or was called, Kharijitism. I may be pronouncing that wrong, but it does not follow either the Shiite or the Sunni models of a caliph. And again, where each person would be equal and have their own connection to God. And this would be consistent with Akhenaten. This would be consistent with the original concept of Aman. And so even when it comes to religious reformation, we see often an equal commitment to equal protection of the law as being the central tenet, as being the central attraction for people to join with the group, the state, the religious order, what have you. But it's not all good. Again, we can talk about the Islamic or Arab domination of North Africa there, right? And so we see the conversion of North Africa from African cultural unity to a blend. But we still see from matriarchy, matrilineality, the resistance of African culture. So we talk about great warrior queens such as Al-Kahina, who was there in 800 AD and led forces to resist the domination or the Arab conquest of North Africa. Somewhat in vain, because it happened. But we also note that it's a little exaggerated in that we know that it was more syncretic. And what I mean by that is, yes, Islam came to dominate North Africa, spread throughout West Africa. However, you can read from Islamic scholars themselves that African cultural tendencies or African cultural dynamics permeated and created its own brand of Islam, and once again, most obviously through women. Arab scholars complain bitterly about the presence, again, of female queens, of women that had male friends without their husband's consent or permission, and other issues generally, right? But then we also see some other fantastic things about the relationship between Islam and black folks. So we immediately go from the Arab conquest of North Africa to kind of an equilibrium that helps ancient Ghana grow to the wealthy stature it maintained through the gold trade, right? By Africans controlling the gold mines, and Arabs, or at least Africans that were African Muslims in the north controlling the trade routes, Ghana became one of the richest places in the world. And little known to me until about 5 or 10 years ago, perhaps the first human rights record, the first human rights treaty, the Kirkan Fuga, is created to establish friendly relations between the citizens of Ghana and have the rights of Arab Muslims that resided there. So before we had the Magna Carta, and there's some dispute about that, of course, they won't let us be first. I really don't care. It's early enough to me to be ridiculously impressive that ancient Ghana operated under a legal charter that regulated the treatment of foreigners, right? So again, equal protection of women, equal protection between the poor, the rich and the poor, equal protection between native folks and foreigners. Again, Mansa Musa or Suleiman Ali were credited by Arab scholars. They say the Mansa of all peoples of the world, it is the Negroes who abhor injustice the most. They pardon no one who's guilty of it. Again, that as a firm accreditation of commitment to equal protection from thousands and thousands and thousands of years. Doesn't stop there. We know that before there was European slavery, there was Islamic slavery. However, and from that Islamic slavery, we then have the claim that Africans sold other Africans into slavery, which is true. However, again, it's more complicated than that. Just as some felt as though they were superior through what they called al-Kitab, being of the book, meaning that if you were Islamic, Christian, or Hebrew, that you were exempt from slavery, and all those of native African religion were not. We actually get the curse of Ham started through Islamic sources, the idea that Ham was black and inferior for looking upon his father or something ridiculous like that. And so we had that dynamic in Africa, but proudly we have lots of evidence of resistance to slavery and a bevy of African free states. Most notably, again, led by a woman, Queen Nzinga, who created Angola, was the queen of Angola, who aligned herself with other nations such as Matamba, and probably never heard of these places, but they actually were great states that banded together, and if you touched soil there, slavery was not allowed. So as the North had this competition, and then the Portuguese come along and they also start in the slavery business, there were states, whole states that were created to resist slavery. So on the one hand, you can dwell upon certain instances where you did have slave trading in Africa, and we'll get to that. There were a lot of notorious slave traders, the Jaga, Tipo Tib, and what have you, but there were also tremendous resistance movements, and towards that resistance movement is none greater and none more impressive than the fact that two African philosophers, Zaro Jacob and Wilhelm Amo, Zaro Jacob from Ethiopia and Wilhelm Amo, who was Nigerian but taught in the universities of Germany back in the 16th, 17th century, taught that all men were created equal and resisted slavery decades before Immanuel Kant, before John Locke, before this Enlightenment. So the idea that all men were created equal as a philosophy was written by scholars in Africa before the European Enlightenment. So deep is the commitment to equal protection of the law in African states, and it continued all the way into the United States. When we look at the African American legal community, especially the scholarly community that holds themselves out as what we call critical race theory, if we wanted to rename it, it would be anti-subordination law, right? How the law, even if it doesn't state it, right, through pretext, how neutral, first of all, to banish blatantly discriminatory laws, but the current aim and lion's share of scholarship in critical race theory right now, the present, deals with how neutrally worded laws have the effect of perpetuating racial subordination. And to even be more specific, some of the great constructs out of this grander project. Kimberly Crenshaw, with her concept of intersectionality, has blossomed all over the Legal Academy to show that when we talk about blackness, we might have different consequences or different dynamics relating to black women or black men. So I am so sorry. So we have also Derek Bell, one of my favorites, and the creator or the author of Faces at the Bottom of the Well, which includes the concept of Afrolantica or Afrolantica Awake. He is also the author of Interest Convergence Theory. And we're going to talk about what interest convergence theory is, because it is also a construct that has basically come to, I don't want to say dominate, but permeate even American legal jurisprudence, especially though that practiced by what's called critical race theory. So that's how we're going to take our study of African legal history, of African history period, all the way from 4000 BC to 2019 AD, 6,000 years of African commitment to equal protection. And then I will offer in the next series after that, this will be part 2 of the book Afrolantican Jurisprudence, what we should do from there. I propose that a legal conception of racism as asymmetrical market imperfections is the way to carry that commitment to equal protection into the 21st century. The way to respect interest convergence, the way to respect intersectionality, the way to respect the law and economics, and to carry our scholarship further into what could possibly be a better system than the one we have, not just for black folks in America, but for America itself, for the world itself, because all of us ought to be looking for not just what's wrong with the system, but what the better one is. So we're going to stop here and conclude. I'm sure that was a lot to digest. I would like, hopefully, for you to stop by my YouTube channel, Afrolantica, afrolantica.com, and subscribe to that channel. If you have any questions that you'd like to throw out there, or comments or suggestions, I know this is very crude. I just decided that I had to go and do it without it being perfect and what have you. We'll work on everything that was wrong, especially even the phone ringing the other a couple minutes ago. We're going to try to shape all this up. Maybe we even redo this again and edit it, but we just have to get started. No better time than the present. Also, please go to Amazon.com and check out Taxes, Death, and Trouble: How Starve the Beast Tax Cuts Created the Black Lives Matter Movement. That's how I'm eating right about now as a retired law professor and trying to kick a couple kids through college. So at last, I would say all this culminates into what I think the plan is. I just ask that everybody, that in order for us to combat white supremacy in our daily lives, that we better educate ourselves, start and patronize black businesses, and that we stop unduly criticizing each other. Hotep.